When somebody gets arrested for DUI and they give blood and the result comes back above the .08 limit, a lot of times they feel like the case is over. It's just open and shut and there's nothing they can do. But the fact is, a lot of these cases are still defensible. I worked as a prosecutor for 5 years and now for 9 years as a defense attorney. And I've worked on literally about 7,000 DUI cases. And I can tell you from experience that a lot of times it's possible to challenge and attack these blood test results. And really, there's 5 things to look at, or 5 ways to attack a DUI blood case. The first is in the initial collection of the blood, because a lot of times it's improperly collected by the nurse or the phlebotomist. Secondly, we find that a lot of times they failed to use the proper amount of preservative and anticoagulant in the vial in which they collect the blood. And when that happens, it's very easy for the blood to ferment and for it to produce its own alcohol. And obviously then when it's tested, it's going to be a higher result than what the person's true B.A.C. was. Thirdly, there's what we call chain of custody issues. And that is that police and crime labs and people in evidence lockers tend to be very sloppy in how they store and mark and inventory blood results. And it's not uncommon for samples to be switched. We see it in the movies, but the reality is it happens not uncommonly in real life. Fourth, we find that a lot of times the chemists who do the blood analysis do it wrong. And one of the things that we do here at Schaus Law Group, in every DUI case that we handle in which there was a blood test, is we do what's called a blood split. And that is, when the police collect the blood, they send a portion of it to the crime lab to be analyzed. But we get the remaining portion and we have it retested in an independent laboratory. And a lot of times we get a different result. And we find that the original analyst at the crime lab did it wrong. And when that's a situation, frequently we can get the evidence excluded from court and get the case dismissed that way. Finally, even in a situation where the police and the crime lab do everything right and the blood test comes back above the limit, that doesn't mean that that's what the client's B.A.C. was at the time of driving. Because when you drink alcohol, it can take hours for that alcohol to absorb into your bloodstream. And as the alcohol is absorbing, your B.A.C. is going up. So if the police take your blood sample and let's say it comes back at 0.11, it may have been that an hour earlier, your B.A.C. was at 0.07 at the time that you were actually behind the wheel. And that's the only thing that counts for legal purposes. So quite often in these cases, we find that blood was improperly collected, that there wasn't the proper amount of preservative and anticoagulant, that it wasn't properly stored and inventoried and could well have been mixed up, that it was improperly analyzed, and that even if it is above the limit, it doesn't necessarily mean that that was what our client's B.A.C. was at the time of driving. So if you've been arrested for DUI and you have a blood test that came back above the limit, we would encourage you never just go in and assume you're guilty and plead guilty. Let a good defense lawyer take a look at your case. Many times it's possible to get these reduced or dismissed.